Good morning, friends. Today I have come up again with a new video on the intellectual property rights. The focus of this video is to clear out various misunderstandings about intellectual property rights among the business owners, researchers, inventors, or the various decision makers of your business organization. A very common misunderstanding among the intellectual property stakeholders is that IP rights are universal and automatic protection is available for their creations across the world. This could be a very fatal for your business organization. For example, if you have a trademark protection in India and you wish to operate your business in other countries of the world, then you need to ensure that you get trademark protection for your brand name in those countries also. If you fail to do so, then there is a high probability that someone else may also seek registration for your brand name in another country. So those businesses who are targeting to become multinational businesses, they need to have a proper strategy for their IPR protection in India as well as across different countries of the world. In another example, if you have a patent in USA, it does not mean that you will get protected in India. You must have filed patent protection in India to enjoy IP rights in India. Except for copyrights, in almost all kinds of intellectual property rights, you need to go in that particular country, apply for IPR protection for respective intellectual property right in that country, and then enforce the intellectual property rights in that country. The second common misunderstanding among the IP stakeholders are that laws and procedures of IPR laws across the world are same. We need to understand that IP rights will be governed by the local laws. There is no such universal patent law or a universal trademark law that would define what kind of brand names will be protected under the Trademark Act or what would be inventions protected under the Patent Act. Yes, there are common principles, but overall national laws vary from country to country. Let's take an example of a patent. The basic principle for patent protection across different countries of the world is that invention must be novel, invention must have an inventive step, and it must have an industrial applicability. But in certain countries, including India, we have additional layer of protection to ensure that monopoly created by the patents is not exploited by the patent owner. That is why the Indian Parliament have included a section 3 in the Indian Patent Acts, which has put up an additional layer of requirements to seek patent protection in India. So even if your invention has novelty or an inventive step or an industrial applicability, but if your inventive portion of your invention falls into the section 3 of Indian Patent Acts, Indian Patent Office will not give grant patent to such inventions. So therefore, even though the basic principle across the world are same, but the intellectual property creations will be governed by the local IPR laws. This is equally applicable for another form of intellectual property rights which covers trademark, copyright, Plant Variety Protection Act, as well as the geographical indications. Now I'm going to share a fatal misunderstanding among the IP stakeholders, which is that I have my own IPR and now I can sell in the market either in the form of products or in the form of services without checking any competitor's IPR. So what does this mean is that we have developed a misunderstanding that if I own some intellectual property right, let's say a patent for a invention, then I can straightway launch the product. I do not need any approval from the competitors or let's say any third party person who may have patent in that particular domain. This could be a fatal for your business decision, because if you get infringed by third party patent, then you have to stop all your commercial activities. So let me give you a very simple example. Suppose I am an inventor of a keyboard which can be detached from the laptop at any point of time while operating the laptop. If I have obtained a patent protection for such kind of detachable keyboard, and then I wish to sell a laptop with such kind of keyboard without seeking clearance in the market from third party vendors or from other companies who may have thousands of patents on a laptop, then this misunderstanding of not seeking approval from the third party persons will going to kill my business on the very next day of launching my product. So that is why it is very important for you as a business owner to ensure that you do not infringe someone else's intellectual property right. It is applicable for trademark, design patents, copyright, and patents, and any other form of intellectual property right. And I hope that this point is now very clear to you, that even though if you have an intellectual property right for your invention, for your brand name, you need to ensure that you are not infringing someone else's intellectual property rights before launching the products in the market. I will continue to update you other misunderstandings or myths about intellectual property rights in my next video. Thank you.